The gang's all here.
Yeah, I see. Good. All right. Yeah, so the screening stuff. It's just a regular.
Good evening. We're going to open the public hearing for Park Central. We're waiting, Mr. Petrie's not here yet, so
He's not coming.
he's not coming. What do you mean he's not coming?
I'm here as his representative.
Okay. All right, so we're going to open the public hearing. Mr. Kenley, you want to start then?
Yes.
I'll give you this mic so you don't have to use the two attorneys can.
Well, in connection with the applicant,
Chin, is that on? Excuse me, is that mic on?
is now.
Yes, thank you.
Mr. Chairman and members of the board, Angelo.
Excuse me, 1 minute. Yes, sir. There's only 4 of us sitting on this. Yes. Go ahead.
Angelo Catanzaro, I represent the applicant on the pending Chapter 40B comprehensive permit application. And tonight, we are going to be requesting a further extension. I have a written request for that extension. There's an extra copy. The reason for the extension is we think we're at that point in the process where we need to move forward with engineered plans for this project. My client estimates that it'll take approximately 4 to 6 weeks, maybe a little bit longer, to get those plans. Then I know there's going to be a peer review process that'll probably take another week or 2 or more to review those plans. So we would be asking that we schedule the next public hearing sometime in early April. My request also provides for an extension of the deadline to make the decision till the middle of May. And I thought that those dates obviously are up to the board's discretion, whether or not you want to continue till April, and if you believe that enough time after an early April meeting to render the decision in the end of May would be sufficient.
Okay, question 1 is, what plan is being submitted?
There is no plan being submitted. It's the plan that has been submitted.
The original?
The original, yes, the original 40B for sale project.
For sale project?
Correct.
So then you're saying that Mr. Petrie is agreed that he's going to not do the rental project for the town of Southborough?
We're going forward on the for sale project at this time because we have been unable to reach an accord with the abutters as to the scope of the engineering required for which would be the rental project. And so what I'm saying is yes, at this time, we're going to go forward with the 40B as we originally filed. There's been probably a 4 or 5 month period in which we've attempted to work out an alternate to accommodate the board because we were very sensitive to this board's feeling that a rental project would be something that the town wanted. We've done everything that we could, we've thought, to accommodate that. We've relocated points of access. We've moved the buildings from one section of the site to another. We actually hit a very small impediment, but that impediment has proven to be the end of the line for my client. And so we don't want to delay any further. I've indicated to the abutters that if something changes in the next week or so, I would be willing to reconsider it. My client and his investors are adamant, however, that we move forward with this project, and we're not going to have any more delays, as few as possible anyway.
Okay, one question would be then, that the board would be able to involve the town engineering company that represents the town, Faster O'Neill, to review this project. So I'd like to be able to, Mr. Petrie, you agree that we're going to use them to do it because they've done all the work for the town and we've done additional 40Bs with them, which I've been involved in, so we can get that process up and ready also.
Absolutely, and we anticipated that you would be having a peer consultant review everything else that we filed in connection with the 40B.
Okay. Any questions for the members of the board presently on this? Okay, the dates we have here, The extension is until May 21st, 2015. So I'd like to have a motion on that first from a board member.
What would be the date of that?
May 21st, 2015.
Yeah, Mr. Chairman, that would be the deadline.
That's right,
Right.
the deadline, then I'm going to go back, once we agree on the deadline of the date of the hearing.
And I could state for the record that that deadline, obviously, we're flexible with that if the
At that
board,
time.
if the board requires more time, but we think it's important that we at least have an end in sight.
Can I have the calendar?
All right, I'll make a motion to extend the application until May 30th. Is that the date?
No,
May
May
21st.
21st.
May 21st,
2015.
2015.
Do we have a second?
That's extending the deadline.
Yes.
That's right.
I second that.
Okay, any further discussion? All in favor? Aye. Okay. Okay. You would like to do this the beginning of April, right?
If that's possible, Mr. Chairman.
Okay, I've got one question, and I'm going to ask town council because I'm not 100% sure. Do you know what the schedule for town meeting is in April? Is it the first or second week?
Second week, I think it's, I believe it's April 15th, I think.
That's what I thought. Okay. So would the board be interested in doing the public hearing on April 8th, which will be the second Wednesday of the month?
Is there a reason why our scheduled meeting for the end of March wouldn't work? I mean, we meet typically the last Wednesday of each month.
I don't know. I mean, it's just as likely that we could be ready. What would be the date in March?
Well, the reason I said April is what you just previously said.
I know, and the reason that I said April was because I was told it was going to take about eight.
I would say the March 8th, 25th, isn't it?
Say that again?
The March date?
Yeah, March 25th.
Yeah.
Last Wednesday?
Yeah. Right. The thing is, I personally think if we're going to have a submittal, and it's going to be a permanent full submittal on the 40B, I personally think that should be basically the only thing we do on that night, because it's going to take a couple of hours to do that, won't it?
And I would imagine, and I can't tell you with certainty when we would get you those plans so that you can get them to your consultant.
Well, we need to, what we'll do is I'm going
Well,
to talk to
excuse
the
me,
consultant.
but unless they ask for a continuance, and then we meet when we're not really scheduled to meet, just to hear that they're asking for a continuance.
I don't mind the 25th of March. It's really up to the board.
Well, my thing about it is I don't think we should, the 25th of March is a regular meeting night that we're going to have with other items. And I think this particular item is going to take a couple of hours. So it should, I think, go on a separate night than that one particular night, so whatever our other agenda is.
Okay, I'm fine with it
The
then.
only reason is, and then as far as engineering goes, I'm going to talk to, I'm going to talk to the board to give me permission to talk to Foster O'Neill. And then I will ask them to come to that first presentation, so when you make it, they'll be here and look at it, then they'll take it back and do their review and everything on it.
I'll have it to them before they even have to come here that night, so they
Well-
can be prepared to.
Well, we have to get a quote from them, and there's a bunch of things we have to do
Okay.
before you can do that, all right? To make it legally on
We have
on
no
the
objection
process.
to them being present at any of the meetings.
Right, and then we'll set it forward. So, can we get a motion, what time would you want to do that? 7 o'clock, all right?
7 o'clock, fine? with
Okay,
you?
so can we
April
get a
8th?
motion to
Yeah.
continue the public hearing until April 8th at 7 o'clock?
Go ahead.
I make a motion to continue the public hearing till April 8th, 7 o'clock.
Do we have a second?
I'll second it.
Okay, any further discussion? All in favor, aye. Okay, thank you. We're going to now reopen the public hearing for the use variance, which is scheduled at 7:35, which we got a minute to go. So, Caranzaro, you're going to make the discussion on that, on the use variance where we're at?
Yes, my discussion is very brief. I am going to formally request that the board allow us to withdraw the application for a use variance without prejudice. As we've indicated from the very beginning, the entire concept of the use variance and that, of the project based on that, and I believe we had actually gotten to the point where we've submitted concept plans of what we had hoped to do, was really dependent upon a comprehensive written agreement with abutters. Attorney Hill and I have worked hard to get to that point. We were unsuccessful. And there's no need to further delay the process or to draw it out. We would ask to withdraw it. If over the next week or two, we make progress and we actually come to an agreement, I will refile. Because I think it's at that point now where there have been so many changes from the original plan anyway, I was going to need to modify the use variance regardless. So if we have the abutters on board and we're going to do this as a team, abutters and developer, and we all agree, we'll refile.
Okay, can you give us that in writing, please?
Yeah, yes, I can.
Okay?
A request for a, yes.
Yeah. Did the board
Withdraw.
have any further discussion on that?
The only question I would have is if it's withdrawn, that doesn't have any adverse effect. If you try to then you would try to.
If it's without prejudice.
Without prejudice,
Yes.
and that wouldn't have any effect on
The future?
the future if you try to resubmit.
Right, it would take it out of the category of repetitive petition.
Okay. Then,
All right, so can we get that in writing?
Yes.
Can we have a motion then to accept the withdrawal on the use variance without prejudice?
yeah, sure. I'll make a motion to accept the withdrawal without prejudice.
Okay? Any further, use variance?
Without prejudice.
On
I'll
Park-
second it.
on Park Central.
Right.
So it's clarified.
And I second that.
Okay, any further discussion? Okay, all in favor? Aye. Okay. So, Mr. Cavalieri, would you submit that to us so we have it on file?
I'm completing it right now, and I'll submit it before I leave.
Okay. So we need a motion, I guess, to close the public hearing, which I probably should have done first before we voted. I apologize for that. So let's make a motion to close the public hearing on the use variance.
I'll make a motion to close the public hearing on the use variance.
Okay, all in favor? Aye? Okay, the other thing is I apologize that I should have done that first instead of making the vote. So let's redo the vote now that the public hearing's been closed, as you just did, Mr. Eagle.
I make a motion to close the public hearing.
No, we did that when we voted. The motion is to accept the withdrawal.
Oh, that was his motion.
Yeah, Tom?
So I'll make the motion to accept the withdrawal without prejudice of the use variance.
Okay. Discussion with amongst the board? Okay, all in favor? Aye. And I apologize that I did not do that in the right way in the beginning. Okay, our next public hearing is at 8 o'clock, so, can we get a 10-minute recess in between? Okay? Okay, thank you. Karen, is your phone talking over there? Okay. Good evening, we're going to open public hearing. You guys ready? Okay. Karen, you want to read the document, please?
So, which one first?
No, the document on the public hearing notice first.
Oh, yes, sorry about that.
And we'll read the other documents after.
Appeal of letter and decision of building commissioner dated November 18th, 2014. Petitioners Karen and Peter Shimskis, 8 Lynbrook. Amon and Manpreet Kurana, 6 Lynbrook. James Carney, 26 Lynbrook. The Board of Appeals of Town of Southborough will hold a public hearing in the hearing room of the Southborough Townhouse, 17 Common Street, on Wednesday, January 7th at 8 p.m. with regard to the request for enforcement of the zoning bylaw in terms of the 1983 variance pertaining to the property listed above. Specifically, requests that the Zoning Board of Appeals revise the decision of the Building Commissioner Robidoux determination letter dated November 18th, 2014, stating that there is no zoning violation on the property and no zoning enforcement action will be taken. The petitioner is seeking enforcement under Section Use Regulations 174-8.2. A copy of the application may be viewed at the office of the building department at the town hall during normal business hours. Leo Bartolini, Chairman.
Karen, will you then read the first letter that was written by the first attorney that,
Donald O'Neill.
did the complaint with the building inspector?
Okay, so a letter from Donald O'Neill dated November 7th, 2014, to Mark Robidoux, Building Commissioner, Zoning Officer, Town of Southborough, and it's a request for enforcement. Dear Mr. Robidoux, on behalf of the undersigning abutters, this letter serves to formally request enforcement of all applicable provisions of the Southborough zoning bylaw as it pertains to the operation of the business being conducted at the above captioned address, hereinafter the site. The undersigning direct abutters to the site are aggravated by the resumption of prohibitive activity in the portion of the site located at the intersection of Lynbrook and Main Street, known as The Point, in direct violation of a previous order dated July 9th, 2012, issued by your predecessor, David Gasmini. Mr. Gasmini's order was issued in response to a prior request for enforcement that I made on behalf of the abutters by letter dated June 4th, 2012. I enclose herewith copies of my prior requests as well as Mr. Gasmini's order. The site is residentially zoned with the business activity being conducted hereon, subject to terms of the variance granted by the Zoning Board of Appeals in 1983. In response to my prior request for enforcement, Mr. Gasmini ordered the removal of all piles of debris, loam, and other items from the point and specifically noted the owner of the site that future storage of materials were to be restricted to the area located behind the garage barn at the rear of the site, as stated in the original variance granted by the Zoning Board of Appeals in 1983. The original application and grant of variance noted the following requirements and conditions: neat and well-kept manner of operations, the employment of a maximum of 4 people at peak landscaping times, the provision and sufficient off-street parking for employee vehicles, the housing of vehicles used for the landscaping business in the pre-existing commercial garage located next to the residence located at the site, and that there was no offensive noise or excessive traffic associated with the business conducted. At the present time, the business currently being conducted at the site bears no relation to the activity allowed by the terms of the use variance granted, and the area of the site used for the business purposes has gone from being neat and well-kept to unsightly. Following the issuance of Mr. Gasmini's orders, the present operator at the site cleared the point as directed, and a period of relative calm resumed in the neighborhood until this past June, when the current operator resumed the stockpiling of gravel and other debris at the point. Since that time, on a periodic basis, primarily on a Saturday and/or Sunday, numerous truckloads of stone have been dumped all day long on the site in the point area in blatant disregard of Mr. Gasmini's 2012 order. I enclose herewith a number of representative photographs showing the dumping and stockpiling of gravel at the site that has occurred since June. It is my understanding that in response to complaints made about the resumption of prohibited activities, you ordered and/or permitted the operator to level the piles being dumped at the point, apparently in an attempt to comply with the terms of Mr. Gasmini's 2012 order. We agree with your finding at that time that the operator was in violation of the order then, and your observation that the site was an unsightly mess. Under this arrangement, however, the stockpiling on the point has continued unabated, with the neighborhood residents being subject to associated noise, dust, and heavy truck traffic, to the extent that parents of children living in the neighborhood are concerned for their children's safety. In my opinion, the ongoing activities at the point represent a safety issue and a stockpiling of materials, notwithstanding the spreading of materials that has occurred. I submit that the total volume of materials dumped at the point is the determinative factor that needs to be considered, as opposed to the configuration of the pile. The adverse impact on the neighbors associated with the ongoing activities at the point remain the same, regardless of the way the material are being stockpiled. I respectfully request, on behalf of the undersigned abutters, that you review the terms of the original variance, my prior request for enforcement, and the order issued in response thereto by your predecessor, that you take immediate action to stop the ongoing dumping and stockpiling activities at the point, and order the removal and relocation of the stockpiled material. As I mentioned to you on November 3rd, 2014, the source and composition of the materials being dumped on the site remain a serious concern to the abutters, separate and apart from the zoning issues presented. In any case, your help in resolving the zoning issues related to the ongoing dumping and stockpiling would be greatly appreciated by all concerned. Under the provisions of MGL 40A and 13, you have 35 days to respond to this request for enforcement. Failure to respond within this period will be deemed a denial of the request made hereby and grounds for an appeal to the Zoning Board of Appeals. If you require any additional information, please let me know. Very truly yours, Donald J. O'Neill, and the signatures of the abutters.
Okay, Karen, you have a letter from a couple of abutters that signed the same letter. And one thing, so the board realizes that this first letter was done by an attorney, which is no longer in this process, the new attorney, which is representing their neighbors now. And it was the letter that the building inspector used to write his decision on the, against the use variance of being legal. And we have a letter from two abutters, or three abutters. I'm going to read that. Then we have another letter from the new attorney that's representing them, which I'll have her read that next. Karen, would you go
So
ahead?
this is dated December 22nd, 2014, to the Zoning Board of Appeals, and it's regarding 1 Lynbrook Road. Dear members of the board, we are writing this letter in support of the appeal of Karen and Peter Shimskis from the Building Commissioner's November 18th, 2014 decision relative to the 1 Lynbrook Road site. Please note that we are former owners of 6 Lynbrook, which is an abutting property to 1 Lynbrook. We reside at 6 Lynbrook Road until 2003, June. As abutters, we agreed to support the then proposed variance, granted solely on the basis that Rocky would run his own small business from the site. The abutters, including ourselves, agreed to support the proposed variance on the condition that Rocky's landscape remained the same size small business and remain out of view, with all related trucks and equipment stored in the storage shed behind the house. Importantly, at the time of the proposed variance, no materials whatsoever were being stored or stockpiled on the point section of the site, nor were any materials historically stockpiled on the point section of the site prior to the grant of the variance. In fact, to the contrary, at the time, the point section of the site had always been kept in a neat condition, that the site would continue to be kept in a neat condition, and all materials and business activities continue to be kept out of sight and contained to behind the house located at 1 Lynbrook Road, was of critical importance to us and the other abutters in the neighborhood, and was a condition of our support of the variance. We and the other abutters would never have supported the variance without the above conditions. Any placement of materials or activity obtrusive or disruptive to the neighborhood was agreed as prohibited and a necessary condition of granting the variance. I hope you find this information helpful. If you should have any other questions, please do not hesitate to contact us at the above address. Thank you. Sincerely, Richard G. I think it's Holloway or Halsway, and his wife signed as well, and Halsey, and I can't read her first name, sorry, but Mr. and Mrs. Halsey.
Okay. Karen, this is the other letter that you need to read in the record, please.
Okay. All right, so this memo is from Bowditch and Dewey, the attorneys, to Paul Berry, town clerk, reference 1 Lynbrook Road, determination of building commissioner, dated November 18th, 2014, notice of appeal. Dear Town Clerk Berry, please be advised that this office represents Karen and Peter Schminskus of 8 Lynbrook Road, Eamon and Manpreet Kurana of 6 Lynbrook Road, and James Carney of 26 Lynbrook Road, all of Southborough, Massachusetts, collectively the applicants, as persons aggravated by the determination of the building commissioner, Mark Robidoux, dated November 18th, 2014, that there is no zoning violation on the property and no zoning enforcement will be taken. Notice is hereby given of their appeal to the Zoning Board of Appeals from the November 18th, 2014 determination of Building Commissioner Robidoux, and 10 copies of this letter and the following materials are closed herewith. 1, appeal application form with 1983 variance attached as Exhibit A. 2, building commissioner's determination dated November 18th, 2014. 3, photographs of the property showing violations. 4, certified list of abutters. And 5, a check for the amount of $300 for the filing fee. The grounds of this appeal include, but are not limited to, the following. 1, there has been an unauthorized expansion of the landscaping business beyond the restricted activity allowed by the terms of the condition of the use variance granted by the Zoning Board of Appeals in 1983, parentheses, the 1983 variance. 2, the commercial landscaping and other business activities currently operating at the property are not permitted uses in the Residence A zoning district pursuant to Section 174(8.2) of the Southborough zoning bylaw, the zoning bylaw. 3, the prohibited activity at the property are in direct violation of the previous order dated July 9th, 2012, issued by David Gasmini, Building Commissioner, Robidoux's predecessor. The prohibited activities on the property include, but are not limited to, dumping and stockpiling of materials on the portion of the property located at the intersection of Lynbrook and Main Street, known as the Point, parking of heavy equipment and vehicles used for the landscaping business in the open rather than being housed in the commercial garage located in the property, business activity and parking of vehicles on the property by businesses other than Rocky's Landscaping, offensive noise, dust, and heavy traffic at all hours, and beehives being kept on the property. The property has become unsightly and degrades from the neighborhood, and such prohibited activity endanger the health and safety of abutting residents. The applicants reserve the right to advance additional grounds for this appeal. The applicants seek enforcement of the zoning bylaw in the terms of the 1983 variance, and specifically requests that the Zoning Board of Appeals revise the decision of the Building Commissioner Robidoux and issue an order that, 1, the dumping and stockpiling of materials and all other prohibited activities on the property as listed above and otherwise as found by the Zoning Board of Appeals cease and desist immediately. 2, the property be cleaned up immediately to be kept in a neat condition as required by the 1983 variance. And 3, other terms of the 1983 variance be compiled with, including but not limited to, requiring the parking of heavy equipment and vehicles used for landscape business in the commercial garage located on the property, and prohibiting all business activity and parking of vehicles on the property by businesses other than Rocky's Landscape. Kindly date, stamp, and file this notice of appeal. Copies of this notice of appeal are being simultaneously cross-filed with the Building Commissioner Robidoux and with the Zoning Board of Appeals. Very truly yours, Marissa L. Pizzi.
Thank you, Karen, very much. I have a question for the board before we go any further. Have you all had a copy of the building decisions letter, and you've read it? So you're all aware of this, and I don't have to read it. You have this letter also, so we don't have to read it in the public record, just to save a little bit of time. Okay, so would you, I'm going to give you this mic, ma'am. That on? Is that on? Okay. You can use that mic and sit down, ma'am. Would you introduce yourself and anyone else that you're going to have speak, please?
Sure. Thank you, Chairman Bartolini. My name is Marissa Pizzi. I represent the petitioners in this appeal, Karen and Peter Shimkus of 8 Lynbrook Road, who are both here, sitting behind me, Aman and Manpreet Karana of 6 Lynbrook Road, and Aman is here this evening as well, and the three of, well, some combination of the three of them will be speaking this evening. And I also represent James Carney of 26 Lynbrook Road, who unfortunately is traveling and couldn't be here this evening. May I proceed?
Say it again?
Is it all right if I proceed?
Yeah, go ahead.
Just a couple of housekeeping matters, if I may. Did the members of the board receive, I submitted a memorandum on the 31st of December with attached exhibits that I just wanted to make sure all of the board members received.
Just so you know, we have received it, which basically is wrong, because it's supposed to be done 10 days in advance. And the building inspector is in the process of rewriting all of the regulations. He's done a few of them, but he hasn't got them all done. But this was voted on several months ago by this board. So we did give it to the board members, and they do have it. As long as everybody's agreed they've had it enough time, we'll go forward.
Absolutely, we're
Okay,
fine with it.
so, but just so you know, in the future, everything has to be, the building inspector's rewriting all of these things as we go along, and it takes a little bit of time. But we did accept it.
Thank you. I followed the appeal instructions that are posted online, and I did have someone from my office call to confirm that those instructions were current. So I wasn't aware of the 10-day
Right.
filing.
We just haven't
but
got that form done yet.
Okay, thank you. And I did bring extra copies in the event that, but it sounds like everybody has received
It was
them.
mailed out
Thank you.
immediately, so everybody got it.
Thank you, I appreciate that. I also did receive, late this afternoon, we received 2 letters from commercial property owners in Marlborough and Westborough, whose properties, and I'll be referring to in the course of my presentation, and it's addressed in my memo. These are the commercial property owners whose roofing materials were at various points dumped at the 1 Lynbrook property, and they have submitted letters for submission to the board, which I only received late this afternoon. So if I could, I have 10 copies. I'd like to pass them forward.
Well, you can, but they're not going to be, reviewed tonight. I'm sorry.
Okay, I mean,
they have to be done in 7 days prior, so we can review them and, anything that we need to do. So if you want to submit them, go ahead.
That's fine. I will submit them. I mean, as I said, these were not documents that I prepared and are directly prepared and signed by these property owners, and they asked that we submit them this evening. But I'm prepared to proceed in any event.
Yeah.
So, as I said, I'd like to start by making a presentation and then turning it over to the petitioners who are here this evening to make a statement.
Well, I'm going to let you make your presentation,
Okay.
and then the board is going to have a discussion on it. Then we'll open up to the rest of the public at that time, okay?
Okay, thank you.
So we go and do get started somewhat, then we'll go step forward with it that way.
Okay, understood.
Okay, thank you.
So turning to the appeal, the property that is the subject of this appeal is obviously the 1 Limbrook Road property. And in order for this board to determine whether there is a zoning violation, it is necessary to review the history of the property and applicable zoning. The property, as the board may know, is owned by Clayton Rock Jr., who I understand is now deceased, and his wife, Janice Pachonis Rock. The property is located in a single residence A zoning district amidst a residential neighborhood. The property itself contains a single-family dwelling as well as a large detached garage structure and a small detached equipment shed. The large triangular portion of the property located closest to the intersection of Limbrook Road and Route 30 is known as the Point, and I believe that's been referenced a few times in the letters that have been read into the record. That area, known as the Point, is vacant, but is the site of the most recent violations. I've attached, for the board's reference as Exhibit A, a copy of the assessor's map, which shows the subject property as well as the property of the petitioners. The property, the 1 Limbrook Road property, is identified as Lot 3 on the assessor's map. And just to give some context, Karen and Peter Shimkus, 2 of the petitioners, own the properties that are identified as 10, 10A, and 10B on that assessor's map directly across the street. And to the right, the lot identified as 10C, that is where Aman and Manpreet Khurana reside. And then the lot identified as 11, that is where Mr. Carney resides. And so that just to put it into context for the board. We've heard reference of the variance that runs with this property. That variance was granted in 1983 by the board as it was then constituted. And the variance that was issued was a use variance issued to Mr. Rock to operate, as the variance read, a quote-unquote landscaping business on the property. And that variance is attached to the memorandum I submitted as Exhibit C. At the time the variance was granted in 1983, Mr. Rock had already been operating a landscaping business known as Rocky's Landscaping at the property for 10 years, and that is referenced directly in the decision. Mr. Rock was seeking permission to continue the landscaping business that he was already operating at the property without the required zoning relief. And you'll see from the application he submitted to the board at the time, which is attached as Exhibit D to the memo, that he directly in there states that he was seeking permission to continue the operation of the landscaping business. And in fact, he filed that petition at that time in response to a letter he had received from the Board of Selectmen relative to the fact that there was not zoning relief for that use at the time. Therefore, the variance that was granted was to allow the continuation of the landscaping business as it existed at that time. And that's very important. The variance, and I'll get to the specific language in a moment, but the actual language is very limiting and was to allow the continuation of the landscaping business as it existed in 1983 and had been already operating for 10 years. A landscaping business, quote unquote, is not per se is not per se defined in the zoning bylaw and is not a permitted use under the zoning bylaw. Either by right or by special permit in a Residence A zoning district. And again, it's not really defined as a category of use anywhere in the zoning bylaw. The zoning bylaw does define as a category of use the sale or storage of fuel, lumber, building materials, and equipment in contractor's yard, which is allowed by special permit from the planning board in the business village zoning district and the business highway zoning district. This particular use is not allowed in the Residence A zoning district, and none of the uses enumerated therein are included in the use variance that was granted in 1983. I'm going to turn now to the operation of the landscaping business at the property and its expansion over time. Rocky's Landscaping had been operating from the property with largely no complaints from neighbors and pursuant to the terms of the 1983 variance for quite some time. However, in recent years, the landscaping business at the property has significantly expanded to exceed the scope of the 1983 variance and to include other prohibited activities. These expanded and prohibited activities are pictured in the photographs included at Exhibit E to our memo and include the following: the dumping and stockpiling of large quantities of dirt, gravel, rocks, mulch, debris, and other materials on the point, at times blocking sightlines by the enormous size of the stockpiled material. And this is clearly visible in the photographs that we've attached. The parking of heavy equipment and vehicles used for the landscaping business in the open rather than being housed in the garage located on the property. Again, this is also visible in the photographs we've attached. Business activity and parking of vehicles on the property by businesses other than Rocky's Landscaping. And you'll see in the photographs there's pictures of Orlando Landscape and Wayne's Landscaping, to name a couple, that are, you can see their trucks parked and operating on the property. And also the existence of offensive noise, dust, and heavy traffic at all hours as observed by the petitioners and other neighbors. In response to an enforcement request by these same petitioners in 2012, then Building Commissioner David Guzmini issued a written order to the property owner requiring compliance with zoning and the 1983 variance, and specifically ordered the following actions be taken: removal of all piles of debris, loam, brush, and other items from the corner of the property, which is located at the intersection of Lynbrook Road and Main Street and is known as the Point. Future storage of all materials must be located behind the garage barn at the rear of the property, as stated in the original variance granted by the Zoning Board of Appeals in 1983. And we've attached a copy of Building Commissioner Guzmini's 2012 order as Exhibit G to the memorandum. Following the issuance of that order, the property owner did come into compliance for a short time until the prohibited activities again resumed at the property. As you've heard and as was read into the record earlier, a second enforcement request was made by the petitioners on November 7, 2014, complaining of the same objectionable and prohibited activity as before, and which had resumed, and photographs of the more recent activity showing not only the resumption of the prior activity, but also the expansion of the activity, are attached as Exhibit H to the memorandum. And all of those pictures were from activity in 2014. In addition to the prohibited activities already mentioned, which again resumed, a disturbing pattern of activity emerged with respect to the dumping and stockpiling of gravel and other material at the property. On several occasions, a contractor by the name of RK Hydrovac was observed operating a large vacuum truck and dumping gravel and other material at the property throughout the course of the day. Specifically, if you look at Exhibit H, the photos showing that are the 5th, 6th, and 7th photos in that grouping, and also photos 18 to 21. And you can see the truck and the dumping of the material. Upon investigation, the materials were traced back to roofing job sites in other towns that required disposal of the material at disposal and/or recycling locations other than the property, according to public records. We've attached the public records for these roofing job sites in Westborough and Marlborough as Exhibits I and J, which identify the disposal and recycling locations for the material, and it was not 1 Lynbrook Road, which is where the material ended up. And the letters that I submitted at the outset are from the commercial property owners from Reef and Caruth Capital, who own those two sites, the Westborough and Marlborough site, and who acknowledged that none of their material was authorized to be delivered to 1 Lynbrook Road. Apart from the possible legal implications of such activity, the repeated dumping of material at the property at various times of the day and night, and on weekends, including Sunday, by heavy trucks causing dust and noise far exceeds the scope of any permissible activity at the property. In response to the second request for enforcement, the building commissioner found that there was no zoning violation, contrary to prior building commissioner Guzmini's previous enforcement order, and without offering any explanation for departing from that enforcement order. The reasons requiring reversal of the building commissioner's decision really boil down to 3. 1, the expanded business activities at the property exceed the scope of the 1983 variance. Secondly, these activities are not otherwise permitted in the Residence A zoning district. And thirdly, these prohibited activities endanger the health and safety of abutting residents and are a substantial detriment to the public good. Turning first to the scope of the variance itself. With all due respect to Building Commissioner Robidoux, he erroneously interpreted the scope of the 1983 variance. It is well-settled law in Massachusetts that variances are sparingly granted. In addition, the scope of a variance must be strictly construed based on the language of the variance decision. Where there is ambiguity on the face of a variance decision, it should be resolved against the holder of the variance, which in this case would be the owner of 1 Limbrook Road. As the Massachusetts Appeals Court said in Mendez versus Board of Appeals of Barnstable, it would be anomalous if a variance, by its nature sparingly granted, functioned as a launching pad for expansion as a non-conforming use. And unfortunately, that's exactly what has happened in this case. As I mentioned at the outset, at the time the variance was granted in 1983, Mr. Rock had been operating the landscaping business for 10 years. He was seeking permission to continue that business. And the variance that was granted was specifically for that purpose, to continue that variance. The board need only look to the variance decision itself to determine what was allowed. The variance decision states, the business employs 4 people during the peak landscaping season and provides sufficient off-street parking for their vehicles. The vehicles used for the landscaping business are housed in the barn. One abutter present had no objection to the granting of this variance, providing there is no expansion of the business. The board found that the business had not caused any problems in the last 10 years, and there were also no objections from any abutters. The petitioner had conducted his business in a neat, well-kept manner. The petitioner would be substantially injured if he was not allowed to run this type of business at this location. The board at that time voted unanimously to grant the variance, further finding that there is no offensive noise or excessive traffic caused to the area, that the petitioner has not and will not erect signs or any exterior directionals for the business, and that there is sufficient off-street parking for the employees, and granting the variance does not derogate from the neighborhood. That's what was granted and nothing more. The business currently being conducted at the property bears no relation to the activity allowed by the terms of the 1983 variance. The once small business, limited to 4 employees, has expanded to include use of the property by other landscaping businesses, such as Orlando's Landscape, and the parking of heavy equipment and vehicles on the property in plain sight rather than in the garage is acknowledged and required by the 1983 variance. And again, you can plainly see this in the photos that are attached as Exhibit A and Exhibit E and Exhibit H. The once neat and well-kept business is an eyesore with large piles of dirt, gravel, and other debris stockpiled on the point, causing offensive noise, dust, and heavy traffic at all hours of the day and night, during the week and on weekends. And again, these large piles and even the dust caused by the dumping of material can be seen in the photos. Perhaps most significant is the fact that the 1983 variance makes no reference to the stockpiling of materials at all. And in fact, no such stockpiling had occurred at the property until the years leading up to the first objection by neighbors in 2012. This stockpiling of material, particularly with the frequency and in the quantities that occur, exceeds the scope of the 1983 variance to only allow a landscaping business. A case by the name of Mendoza versus Licensing Board of Fall River, decided by the Massachusetts Supreme Judicial Court in 2005, underscores both the importance of a local board's findings in granting a variance and the nature of the existing use at the time a variance is granted, where the variance is to request the continuation of that existing use, as is the case here. Mendoza involved the interpretation of a 1996 variance, allowing the right to operate a restaurant, lounge, bar, function facility, theater, hall, or other place of amusement, entertainment, or assembly in an industrial park district, which the court concluded did not permit adult entertainment and required the property owner to obtain an additional zoning variance in order to provide adult entertainment. In that case, a restaurant and bar known as Oliver's had operated at the subject property since 1983 as an accessory use to an airport in Fall River. In 1996, the airport closed and the owner of Oliver's received a variance from the Board of Appeals of Fall River to continue operating the establishment. Importantly, the court held the variance confines the property's future use to Oliver's past uses, as is particularly appropriate where the variance holder urges a broad reading of a use variance to support a non-conforming use. We strictly construe the limitation. A strict reading of the variance permit only those forms of entertainment that Oliver's hosted prior to 1996. The local board's findings in Mendoza are similar to the board's findings in the 1983 variance at issue here. And the 1983 variance must similarly be strictly construed to allow only the landscaping business use that existed at the time the variance was granted. and as limited by the board's own findings and restrictions. Building Commissioner Robidoux' broad reading of the variance that there is that quote, there is nothing in the variance that states the owner cannot stockpile materials, and otherwise permitting the expanded business activity at the property is contrary to law and allows the expansion of an already non-conforming use. There is nothing in the variance that states the owner can stockpile materials, or more importantly, that such stockpiling was ever part of the business activity when the variance was granted. The 1983 variance includes various findings of fact and evidence presented, all of which describe the small, neat, and well-kept nature of the business, and no mention of stockpiling materials is contained in the variance. The stockpiling of materials, particularly to the degree recently occurring at the property, is a new use that was never contemplated in the 1983 variance. Furthermore, while Building Commissioner Robidoux acknowledged certain restrictions contained in the 1983 variance, such as the applicant is limited to 4 people employed at peak landscaping time, the applicant has adequate off-street parking, and the applicant cannot erect signs or any exterior directional for the business, he disregarded other restrictions in the 1983 variance pertaining to the neat and well-kept manner of the business and no offensive noise or excessive traffic. Building Commissioner Robidoux also failed to take into account the circumstances under which the variance was granted and which were incorporated into the 1983 variance, namely that no objections from abutters, that there were no objections from abutters as long as there was no expansion, that vehicles used for the landscaping business were housed in the barn, and the fact that the business had already been operating for 10 years without causing any problems. These factors are pertinent because they underscore the small size of the business and the neat and well-kept manner of the business operations that had been conducted on the property up until that time, in which the board was allowing to continue by granting a variance. There is nothing in the record whatsoever surrounding the grant of the 1983 variance that supports the level of business activity being conducted at the property today. Apart from the business activities at the property being exceeding the scope of the 1983 variance, these activities are also not permitted under the zoning bylaw. As I've mentioned, a landscaping business is not itself a permitted use and was only allowed by the grant of the variance. The zoning bylaw only allows the storage of building materials and equipment or a contractor's yard in certain districts, other than the Residence A zoning district, by special permit. The 1983 variance does not include these uses, and therefore they are prohibited under the zoning bylaw and the 1983 variance. One thing that is really important that I really want to emphasize in all of this is that the property owner is not without a remedy here and can seek an amendment of the 1983 variance or apply for a new variance if the owner wishes to expand its business operations. Such expanded business activities should not be allowed to continue under the guise of the 1983 variance when such activities were not contemplated in 1983 and are plainly not covered by the 1983 variance. The board never reviewed the current scope of activity in the context of the 1983 variance, and the property owner has the opportunity to seek the appropriate relief. This will ensure proper review of the activities being conducted at the property, which is in the town's best interest. The standard for granting a variance is very stringent, and the expanded activities at the property should be properly reviewed and allowed only if the standard is met, which was never done in 1983 because the use at that time was different. I would also like to point out that Chapter 85 of Section 3 of the Town of Southborough General Code regulates the filling or removal of materials consisting of more than 400 cubic yards and the stockpiling of materials consisting of more than 100 cubic yards, and requires a permit from the Board of Selectmen. Here, the stockpiled materials have been gradually spread on the property over time, filling the land such that it is now level with Route 30. A portion of the guardrail along Route 30 adjacent to the point is missing, and the filling of the land has created the potential for access to Route 30, which is an additional traffic hazard. The unregulated stockpiling of materials at the property and filling of the land without any review or permit by the Board of Selectmen is yet another reason why the property owner should not be allowed to continue its expanded business operations at the property without the appropriate zoning review or relief. Lastly, I will let the petitioners address the impact of the prohibited activities on the neighborhood, but I do want to point out the following. When the variance was granted in 1983, the board found that granting the variance does not derogate from the neighborhood. And as the board knows, one of the required findings for a variance under the bylaw and under Chapter 48, Section 10, is that relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the zoning bylaw. The zoning bylaw states as its purpose, protecting and promoting the health, safety, convenience, and welfare of the current and future inhabitants of Southborough. Here, the expanded activities of the property endanger the health and safety of area residents and cause substantial detriment to the neighborhood and overall public good. The large stockpiles of dirt, gravel, and other materials on the point frequently block the sightlines to and from Route 30 and create a serious safety hazard in an otherwise high-traffic area. The operation of heavy equipment and even chainsaws at all hours of the day and night, including weekends, results in loud noises that can be heard by area residents, and particularly those living closest to the property, such as the petitioners. The loud beeping of heavy equipment and trucks, such as backhoes and dump trucks, and other offensive noises associated with the operation of heavy equipment and large trucks, disturbs the peace of the neighborhood at all hours, including the early waking hours and sometimes at night. The constant dumping of dirt, gravel, and other materials on the property further creates plumes of dust that often travel into the nearby homes of residents and into traffic on Route 30. The burning of the dumped debris has caused thick gray smoke and dangerous cinder and ash to blow into nearby residences as well. Moreover, the use of the property by other landscaping businesses, such as Orlando's Landscape, as well as for a dumping site with large truckloads of dirt, gravel, and other material being dumped on a regular basis, has substantially increased the commercial truck traffic in this residential neighborhood, whose direct abutters include school-aged children. These activities are without question a detriment to the public good and derogate from the neighborhood and purpose of the zoning bylaw by endangering the health and safety of area residents and creating an unsightly view at this very visible intersection of Lynbrook Road and Route 30. We have included a request for relief at the end of our memo, and it's also in the notice of appeal. And specifically, it's already been read into the record, so I don't know if I need to repeat it. Specifically, what the petitioners are respectfully requesting this board to do is to reverse Building Commissioner Robideau's decision in order that the dumping and stockpiling of materials and all other prohibited activities on the property, as I've mentioned and as are listed in our memo, and as the board may otherwise find, that those uses cease and desist immediately, that the property be cleaned up immediately and be kept in a neat condition as required by the 1983 variance, and that all other terms of the 1983 variance be complied with, including but not limited to requiring the parking of heavy equipment and vehicles used for the landscaping business in the commercial garage located on the property, and prohibiting all business activity and parking of vehicles on the property by businesses other than Rocky's Landscaping. The petitioners further request the board to order that resumption of any of the prohibited activities on the property shall constitute a violation of the board's order and shall be subject to enforcement by the building commissioner and/or the board. That's all I have. Thank you.
The neighbors you're representing, I'm going to allow them to speak before we discuss it with the board, agreed? So if they have a comment to make, they may make them. They have to stand up and
At the microphone.
Up the mic, introduce themselves. Excuse me. I apologize, I didn't have my mic on. The board has agreed to let the people that you're representing speak, so they need to stand up and notify who they are at the mic.
Okay,
Those are the people you're representing.
Correct. I will call.
Only.
Correct. I will call Peter and Karen Shimkus first.
Excuse me, Peter, you turn around, face us, and use that mic.
Sorry.
Thank you.
As current and original abutter at the time of the variance, the following information hopes to shed light on the original request for variance, which our family supported at the time to help Clayton Rock, the property owner and operator of Rocky's Landscaping. In 1983, Mr. Rock submitted a request for variance in response to the town's issuance of a zoning violation for operating a landscaping business in a residential zone. Our family agreed to support the variance on the basis that it would allow Rocky to operate a very small business, Rocky's Landscaping, on the site, provided that it remained small and away from view behind his house. This was the first and primary condition of operation. It would not have been supported by any of us or any of the surrounding neighbors otherwise. Any suggestion otherwise runs contrary to logic and the actual history of the site. The current expanded activities and messy site messy state of the site bear no resemblance to the neat and landscape physical condition of the site at that time, and the site and activities bear no relation to what was originally proposed and supported at that time. The site has gone from neat and clean, per the variance language, to anything but neat and clean. It is a messy eyesore, a moonscape of debris and piles, health, safety, and fire hazards. The size and the amount of huge truck activity is nothing short of ridiculous and completely out of league with the neighborhood, the variance, and the town zone enforcement criteria issued in 2012. Over time, the owner allowed huge piles of mulch, dirt, gravel, and debris to accumulate, which resulted in an enforcement cleanup letter in 2012 written by the Southborough building inspector and zoning enforcement officer, Mr. Gusamini. Imagine the shock and surprise when giant debris piles accumulated again a short time later. Many other companies came and dumped debris so that now the site has been virtually leveled and on the same height as Main Street, Route 30. Of greatest concern are the recent dumpings of gravel which have been allowed to be spread on the site. The town's own 2012 enforcement letter outlines the specific conditions by which the owner of One Lindbergh must comply, including 1, removal of all piles of debris, loam, brush, and other items as discussed from the corner of your property, which is located at the intersection of Lindbergh Road and Main Street and is known as The Point. Note, virtually none was removed and almost all of this was spread out. 2, future storage of all materials must be located behind the barn and the garage at the rear of the property as stated in the original variance granted by the Zoning Board of Appeals in 1983. Note, future storage should be self-evident. The site has received numerous dumpings and huge piles have been and remain in plain view. 3, the removal and relocation of all materials must be completed prior to Wednesday, August 1st, 2012. Note, again, virtually no materials were located as it was spread around at the time. After enduring years of noise, dust, and mess, all in violation of the spirit, logic, and history of the site and its variance, the abutters have been forced to file a complaint. It has been a painful and harmful experience to endure the mess, noise, dust, debris, and danger of huge trucks and commercial equipment on our hairpin turn, Lindbergh Road, and the expanded business operations at the site. However, it is equally painful to be put in the position to seek relief and be at odds with a longtime neighbor over what should be a matter of common sense and courtesy to the very neighbors who helped long ago. We are hopeful that once this history and points of law have been presented, that an understanding will be reached here and now in this forum. The current inspector's letter of November 2014 is very brief and is in response to the abutters' request for cleanup. His letter does not state why, as required by law, there would be no enforcement action, although he noted the site verbally as looking like holy hell. Therefore, simply put, the process calls for this request for a hearing appeal. The site is obviously an eyesore and has received many dumpings of material, all within close proximity of the waterway, drinking supply, and wetlands. Many neighbors, fortunately, have expressed support for enforcement, and several are here tonight. Thank you. Since the site is so visible, i.e. fronts along Main Street, and the eastern tip is home to 2 driveways, bicycle-aged school children who are picked up by the bus twice daily, pets and pedestrians, all in the hairpin turn that is the inherent physical nature of Lindbergh Road, we specifically and respectfully request relief and enforcement action. We appreciate this opportunity to have a chance to talk with you before the board. Thank you.
Thank you. Anyone else?
Next, I'd call up Mr. Carana.
Good evening, ladies and gentlemen. So,
Excuse me, so you have to introduce yourself and give your address.
sure. My name is Aman Khurana, and I live on 6 Lindbrook Road, which is right across from the point where most of the action happens. So we live right across from what has been described as the point. I have a 10-year-old and a 13-year-old, and they play basketball and soccer, and balls have a habit of rolling down the driveway and right outside. And I can tell you, we live in fear of those big trucks that are less than 10 feet away from us, sometimes much less, because that's where a lot of the dumping happens. We have a dog too, which is a completely different challenge. So there are these trucks that come, they make noises, dump stuff, that's just really massive for that road, who are just there at unpredictable hours of the day. And, other than some serious safety concerns that this gives us, it's not like small safety concerns, it's like somebody can get run over, right? Is the fact that it's just, who knows what they're putting down there. And most of the times we get the sense that people are in a rush to dump and leave because they don't seem to be doing the right thing. So they're not even being very careful in how they drive. And, it's just a very dangerous situation. And that's really the core of our problem with the situation. The fact that it seems to not be what was intended, makes us wonder why we have to put up with it. And that's the reason we're here to appeal, is really what it is. Thank you.
Thank you. Is that the end of it?
And those are the petitioners that are here this
Okay.
evening, yes.
We're going to start with questions by board members. Paul, want to start at your end, please?
I don't have any specific question. I understand what, what you're presenting and what the concern is. I'm a little curious from, from, I guess, Mark's letter that, I guess, originally approved the continued use or said it's not a zoning violation, that there indeed in the past had been stockpiling of materials and
They had stockpiled material on that day since the first day he opened that property up as a landscaper. He used to sell bark mulch and stuff and wood chips off of that property since the first day he opened it, back 20-some-odd years ago. There's always been stockpiled material on that property. As a resident of Southborough, I had by there many times. It's always been there. And one issue is, I'm going to interrupt you, Paul, and go
Nope,
just to give you
that's
some
actually
information.
my question,
The
so.
thing about this use variance that was granted is if you go back and it states of what was pre-existing. Well, all these issues were pre-existing. They've been there 10 years prior to this use variance being granted. And this is one of the reasons. Mr. Gasmini's comments on his letter were, I think, subject to a point that I don't know if he really reviewed the original decision and everything that went on. I've talked to several individuals that were on the board that approved the original variance. And the big thing on approval of this variance was the existing conditions. So some of those, these issues are conditioning. Some of the issues that were read by the lawyer that are under zoning bylaws aren't prohibited in a residential district, but because of a use variance, they are. They were granted because of the use variance. All right? So I'll let you go forward, but that's just a little footsteps for a minute.
that was my basic thought, I guess, more so than a question, was this is something that was I guess in existence when I guess Rocky was, so this is something that has been, is it at an elevated state?
Can I respond to?
Beyond where it used to be done, that's now more, I guess, visible or more overflowing?
Can I respond to that? That's a good question. I think, we think of landscaping business and storing some amount of gravel or bark or mulch or loam is not uncommon in a landscaping business, and we recognize that. However, what is happening there and has been happening there in recent years, and if you look at the pictures, is not stockpiling of small amounts of bark, mulch, loam, and dirt that are used in a landscaping business. These are enormous piles of gravel, roof debris from job sites that are being spread and leveled on the property and filling that land gradually over a period of time without review by the Board of Selectmen, who have authority to regulate the filling and stockpiling of materials.
Ma'am, I'm going to correct you in that conversation, because as far as I know, and I've been involved in that type of work in the town of Southborough, that is nothing under regulation of the Board of Selectmen at all.
Okay, there is a provision in the
special
bylaw.
permit required of hauling material off of a site into another site, special permit for it, up over a limited amount of material that you can do it. That particular, what is it?
Earth removal permit.
Earth removal permit.
Correct.
Which that site does not come under that requirement. And I think what is going to happen here in the future is that we're going to have to get a comment on that issue. Right, so let's go through the rest of the board questions before we discuss it anymore. Tom? Paul, you all set?
Yeah, I mean, I guess what you were just saying, it's the only other follow-up question to that is, has the elevation of the land changed? Is there, from a topographical standpoint, is it higher? Has the elevation changed? I mean, is there fill that's now changed the?
You can ask the abutters who are here this evening, and they would know best because they've been living there for all of this time, and they have observed that, and stated to me, and I'm sure that to this board, and you can see it in the photos that yes, the grade has changed and it has been elevated, and as I said, it's now level with Route 30, and with that guardrail missing along Route 30 adjacent to the point, there is a potential for access directly onto Route 30, which is a concern. It's a very serious, potentially serious traffic hazard that has been created.
I don't know why, ma'am, you consider that a traffic accident. Back 7 or 8 years ago, they added 8 driveways to the same stretch of Route 30 within 200 feet of that property.
Legal access as opposed to illegal access is a
But
different
they're not
issue.
using the access presently onto Route 30.
I'm not saying they're using it. I'm just saying it's
The filling
potentially
issue
creating.
also, which I've walked the property recently, they have filled in towards the house, which the grade was up and it went down somewhat to the house. And where they're getting to the house, they've sort of raised that grade and brought it over, is where they're filling. But the actual grade, the Route 30 piece and the wedge there has come up a little bit, but the most of the where they're doing it is going towards the house, which is not near any wetlands or anything like that.
You know, to kind of get back to in something you said in the question you raised, I mean, apart from this issue, I mean, I mentioned the earth removal only as sort of a side note. I mean, I understand that's under Board of Selectmen authority anyway, and isn't anything this board has jurisdiction over. I mean, apart from that issue, the level of stockpiling, I mean, again, is not anything that was considered by the board in 1983. And if you carefully review that variance decision, it refers to a neat and well-kept business, vehicles parked in the barn, no offensive noise and traffic. These are all restrictions stated right in the variance that have very clearly been photographed and observed by neighbors as ongoing violations of the variance. These are not things that have been fabricated. I mean, these are issues that, you know, no one objects to Rocky's landscaping, as far as I know, from any of these petitioners and probably any of the abutters in the neighborhood, from conducting its business operations as it was allowed in 1983. If there is a legitimate reason for business expansion, then they should have to come before this board and present their case as would any other resident in this town. Instead, what's happened is that they've substantially and over time increased the level of activity. There are other businesses, whether it be Orlando's Landscape or Wayne's Landscaping, operating out of that property, dumping snow at that property. I've mentioned the trucks dumping roofing materials. That's separate and apart from the filling issue. I mean, that's not part of their landscaping business. That's dumping of material that has nothing to do with landscaping. These are all things that have gotten to a point where we have far exceeded the scope of the variance that was granted in 1983. And that is the issue that these petitioners have. They're not looking to stop these people from conducting the landscaping business that was originally allowed.
I'm all set.
Mr. Eagle?
Is there anyone here that represents the property owner?
No.
No. And the property owner has stayed the same? I understand, the wife is still alive and she owns the property?
Yes.
Does she lease it or is she running in the operation, do you know?
No, it's her son.
Her son runs it? So, you know, I've been in town for close to 30 years and I've seen this property from years ago, and it has stockpiled mulch and loam from time to time. The ground was always kind of an uneven, you know, murky kind of moonscape type of landscape. I took a ride over there and walked the property recently, and I see that it's like a graveled yard almost. It's nice and flat. You're right, it's close to the same topography as Route 30, which I don't remember it being like that, you know, 20 years ago. Not to say that, in my opinion, it looks worse than it it did, because in some ways, I think it looks better, because it was kind of muddy and murky from what I remember from years ago. But, what does concern me is the fact that it looks like, additional trees have come down recently on the property, which run along Route 30. I'm not really sure what the property owner is contemplating by cutting those trees down. I'm concerned about the roofing material. That clearly is not something that's related to landscaping. If it was dumped there, like a temporary thing, maybe a couple days, just to keep things moving off a job site and then removed off the site. You made a statement that it kind of insinuates that roofing material is now in that ground there, shingles and so forth, and I really kind of question that, if that type of material is buried on that site, because that would really be an issue with boards other than this.
Correct. I mean, well, you can imagine it's obviously a very serious concern of the neighbors. I mean, what they have observed is the trucks dumping the roofing material, and Mrs. Shimkus can speak to this. I mean, she followed the truck, leaving 1 Limbrook Road, going to these roofing job sites, taking this material and bringing it back to 1 Limbrook Road and dumping it. And this has happened. It didn't just happen.
I understand
I know
that,
you're
but
speaking of to whether it was.
No one's denying the fact that it was witnessed that it was dumped there. I want to know what happened after it was dumped there.
Well, all I can tell you, and she may be able to speak to this better, is that it was never. I don't believe there was any observation of the material, whatever it may be, being taken elsewhere off site. The only thing that's been observed is the spreading of this material. Whether it was taken off site under cover of night or at other times, I mean, people aren't there, I understand, with binoculars 24 hours a day, so I think you're right. I can't say unequivocally that it was not. Would you like to hear from Mrs. Shimkus on this point? I think she can elaborate.
Excuse me, Mr. Shimkus, you need to use that microphone.
You want her to come up to the
No,
microphone?
give her the one you got.
No, before you answer, I know you live across the street, but I just want to know if you actually witnessed what happened to the material once it got to that 1 Limbrook site.
Absolutely, and every time.
And what happened?
Absolutely. It would come up, be dumped in these massive trucks. They're very specialized trucks. It's called RK Hydrovac. They're come out of Pennsylvania. And it is a service, actually, that's used by the institutional property owners in the area. The owners use different contractors, roofers, to do the roofing jobs, but they hire this one service to suck the gravel off these roofs that are being replaced, many of which are 30 years older and more.
Okay, but you're not answering my question.
And your question is?
My question is, what happened to the material once it got to that property?
It's in the photos.
I'm asking a question.
Okay.
If you can't answer it, you can say, I don't know.
No,
but I'm asking a question. It's very important.
I watched it spread by Paul Pachonis, Janice Pachonis Rock's son, with his bulldozer every single time. I have dates, times, reported it to the police, took photographs, followed the trucks, had the police on the phone with me while I was following the trucks, and photographed the license plates, the people, the contractors themselves, faces. They show up Sundays in black hoodies and sunglasses, got the whole thing except take their pulse and a temperature read. So I don't know what else to do except to report it to the appropriate authorities and leave it in their hands.
Well, I mean, all we can do is review this zoning issue. If you have other issues, environmental issues, that's something that you'll have to deal with yourself. All we can really address tonight is the zoning issue, and if that zoning approval has been tweaked beyond what I guess is reasonable.
It's to the point where reasonable minds, and we're reasonable, all of us here are reasonable people. This has gotten to the point where it's just ridiculous.
Well, I get that, and I hate to throw people under the bus, but I feel as though that 1983 decision by our board back then didn't really foresee some of the issues that could come up, and maybe they would have been better served if they put something in writing, knowing that, potentially things like this could come up. I mean,
It is a matter of common sense. It really is.
but the bottom line is, having said that, I also feel as though that the building inspector a couple of years ago, our previous building inspector, overstepped his bounds by interpreting that decision incorrectly. I feel as though that he did put certain mandates on the property owner that really weren't part of the original decision, in my opinion. There is no mention about where or what things could be parked there. There's even no mention about the maximum amount of employees. There's a mention in the decision that he made a representation that he had 4 employees on the property, but there's no mention in the decision that he's only allowed to have 4 employees. In other words, he's just making a statement of how his business is that day. He has 4 employees. There's no mention about stockpiling equipment, where it should be parked. There's no mention, even in the decision, that he has to park his equipment in that barn. Even though that he said that he had stated that he had in the past, by granting the zoning approval, the board did not demand that he park this equipment in those barns. The fact that he did for all those years was just, he didn't need to, in my opinion.
Can I?
Well,
Excuse me, excuse
but
me.
it wasn't in the decision.
You need to use the mic to speak, because we're on TV, okay?
I-
You go for, keep going.
I'm going to wrap up just in a second. I just feel as though that the property has been like this for many years. Some of these homes in the neighborhood have come up since then. This zoning variance has been in place for 30 years, over 30 years. I think that it's common sense to assume that companies do evolve a little bit over time. And it's unfortunate that some beautiful homes surround this property, and I feel really bad, but I think that in a perfect world, if the property owner could somehow sit down with you and work out some arrangement, that you guys would be happy with, and they would be happy with, as far as screening and hours of operation, that would make our board's decision a lot easier. And I don't know if you approached them or tried to discuss things with them. It seems like common sense people would be able to come up with that decision. And go ahead.
No, I'd like to just comment on, because you made a couple of, I think, good points and raised some good questions about sort of the interpretation of the variance itself and how it can or how it could or could not be interpreted. And I want to go back to something I said earlier. I think it's really important when interpreting the variance to consider it in the context of the law in Massachusetts, which is that variances are, particularly where they may be ambiguous on their face, construed against the property owner. And they are a form of relief. It's a form of relief that's disfavored and is to be strictly construed against the property owner. What you referenced as various evidence presented and findings of fact in that decision, although, would the decision have been much clearer if it had been explicitly stated as a condition? Yes, but the law does not require that a condition be stated as a quote-unquote condition. And in fact, the Mendoza case I referenced in my memo was a case where the board's findings, listed as a finding in the board's decision, were found to be a condition of the variance. And in that case, the facts were similar in that it was a business use that had been going on for many years. The board found that it had been going on for many years and that the petitioner was seeking to continue that use. And the court held that that was a condition of the grant of a variance. I think the same can be said for this variance. And I think to just allow this sort of expansion over time, we've all acknowledged it's been 30-some plus years, and yes, businesses may evolve slightly from time to time, but this is not a business operation that I think you've heard from the abutters resembles at all what was happening in 1983. And if, in fact, it is a legitimate business enterprise that ought to be operating in this town, then this board should require that the property owner come forward and present his case like he did in 1983 and make a showing, the difficult showing that has to be made under the variance standard, that he will suffer a hardship if he's not allowed to conduct the level of activity that he's operating at the property. And I think I'd be very hard pressed to see how the dumping of enormous mounds of roof material, which has not occasionally happened, but has repeatedly and continuously happened, is part of a legitimate business enterprise. And I do think it's within the board's scope, as part of enforcement of zoning, to say that that use, whether that it's not part of landscaping and it is not allowed, and some of the specific conditions in that variance were that the business was neat and well kept, that there would be no traffic and offensive, excessive traffic and offensive noise or dust, and these are all things that are happening. So I do think that the board has the grounds here and has the evidence before it to limit what's happening at that property to what was allowed in the variance. And if there's to be any expansion, let the property owner come forward and make his case.
The thing is, ma'am, we do not have a legal opportunity to do that. That has to be done through the building inspector. That is his job. He is the zoning officer in the town of Southborough. If there is an issue and something has to be done, then he has to do it and recommend that it come to this board or whatever. We don't have the choice of going out onto a site and say, well, you can't do that. You've got to come in front of our board. We have no say in that issue. When Mr. Gasmini wrote the decision of moving the material off the site, it was during the winter time. And the reason he requested to move the material, which I was involved in because I heard the story, there was snow piled there. And Mrs. Shimkus complained because of the coloring in the snow, if I was told right.
It dumped chemicals on
Right, and that's why,
the public water supply.
that's right, and that's why Mr. Gasmini made the statement that he removed that immediately.
And he didn't.
What?
He did not.
No, but he did it. I mean, there was a lot of, I know there was issues going back and forth, Mr. Gasmini said, but it did get moved.
No, it was never removed.
The snow wasn't?
Wasn't.
I honestly don't answer that because I'm not sure, but I do know that was the reason he wrote the issue to remove the material was because of your complaint, because of the coloring and a chemical or something that was in it. There was something in there.
No.
No what?
That's completely wrong. I went in and met with Mr. Gussamini several times. He was very nice, reasonable, went down and felt that they were in violation because of these enormous piles of mulch, dirt. The mulch alone attracts rodents, but it was also blocking the sight line along Main Street into Limbrook, which is a hairpin turn, dangerous.
Right, well, that's,
So he assured me that, that everything would be not just spread out, it would be picked up, removed, and relocated. That never happened. It got completely, in fact, Paul Pachonis came out one night in his bulldozer after his mother told him he had to clean it up with expletives coming out his mouth like unbelievable, got in that bulldozer and was spewing gravel and stuff all over the site in such a scary fashion that I wanted to call the police. He was out there with his red truck parked with his headlights in a threatening manner into our living room the living room of our house where my husband tries to sleep at night. And this was at night. He's been out there at night at 9:30 at night. 9:30. No municipality allows that. These RK Hydrovac trucks are enormous. They start at 6:30 in the morning and go till 6:30 at night on a Sunday. What legitimate business does that? How would you like this across the street from your house?
there's many businesses in town that work those
Not on a
hours.
Sunday and not on a Saturday. And in fact, if you look at Danvers, I review many zoning codes myself. If you look at Danvers zoning code, they have very restrictive language with regard to at-home landscaping operations. And it says between certain hours. and
But
certain
right,
days.
but I understand that. But on the flip side, a landscaping operation is what, a 5 or 6 month operation, right?
We
is
have
not
no
a
relief. It's
This is
12
not,
months.
the point is that it's not in
We
connection
have
with
no relief.
landscaping.
It's 12 months
Well,
a year.
I understand that, but the petitioner is mentioning large piles of mulch and loom, and these are things that landscapers
Some of it
use.
maybe, sure.
And I suggested that she
Mostly
pursue other
gravel.
avenues if she has issues with environmental impact. of
I've
that
never
site.
known a landscaping business to require use of vacuum trucks that are used to suck gravel, as you heard. I mean, that you can tell that's what it is. It's RK Hydrovac written right on the side, and I looked them up. I mean, that's what they do. This aspect of it is not part of their landscaping business.
See, the thing maybe you have to understand, we do not have the authority to do anything about that part of it.
That's
Because of that particular material that's 30 years old.
we're not
If you
at-
have an issue with that,
Correct.
you need to take it to DEP.
It's the use-
Or you need to go
Right.
through the Board of
But
Health.
that's not what we're asking
our
the board to do.
It's not our
It's the
board.
the stockpiling of that material is a use of that land, and this board, through zoning, has the authority to order what can and cannot happen relative to one's use of land, and it's in fact
But the
listed.
stockpiling is an interpretation of this granting of this variance. And the board at the time, even though they didn't include it in the granting, in the order of conditions, I think that they clearly knew a landscaper has to stockpile loam and mulch from time to time. It's part of during the course of their operation. I don't think anything has changed. The fact that that they continue to do that, and I'm going to take the roofing material out of the picture right now because I think that's a separate issue. The normal landscape stockpiling, I don't see that there's an issue. I don't think he's in violation.
It was always intended to be behind the house.
It's not written. I don't know if you're going to park the trucks behind the house and all the
But
piles.
the
There's
abutters
not a lot
never
of
would have
room behind the
agreed
house.
to the original variance.
It doesn't.
Excuse me, if you're gonna talk, you
There's
need to
not a lot
introduce
of room
yourself.
behind the house. That whole point area is a big open area, and clearly that was the area where they intended to park their loom. And unfortunately, shame on the neighbors for buying property after this fellow was already in place, thinking that he was going to develop it
You were
into a
there
beautiful. I'm not suggesting I'm just saying other people. A lot of homes have been built in the last 30 years in that neighborhood.
I don't think the answer is for people not to live on Lynbrook Road, which is a residential neighborhood,
They
because
have
there's a
to know what's-
landscaping business that's operating by variance. I mean, it's the variance it should be construed against the property owner. I mean, and it's not a form of relief that if somebody came in here today asking to operate this type of landscaping business in a residential neighborhood with the kinds of uses you're hearing, there would be scrutiny of that use, and there would be questions asked
No
of
question
that.
about it. It's a different time.
Correct,
You
but
know,
at
the
that
town
time,
was totally different 30 years ago. So I get that.
exactly. And
I
what
get
was
that.
allowed 30 years ago was what was operating at that property 30 years ago. And I don't think that there's anyone who lives in this neighborhood that would tell you, again, whether there are small amounts of loam and dirt for the landscaping business. I mean, I don't think anybody would object to that. I think it's this. I understand why the
I
roofing
understand that,
material
but
is
you know
different.
what? Times change. I mean, there were textile plants in Corderville many years ago, and I'm sure those neighbors nowadays in those neighborhoods wouldn't want that either. I don't want to take up too much more time, but you know, I've said my piece. I think you understand.
I think
where
it's
I'm
I understand what you're saying, but I think ultimately it comes back to how what the law says about interpreting variances
Excuse
and how
me,
they're to
ma'am,
be
I'm gonna
construed.
interrupt you, because you've repeated the same thing about 7 times in the last 15, 20 minutes. I want to let the board ask the rest of their questions. We know you have an issue with the zoning and where that is, and that's something that when we get
Just
into our
doing my best to
decisional
answer the questions of the board.
approval, but to keep repeating the same thing, I disagree with that. I don't know if the board agrees or disagrees with me on that.
I'm answering the questions that are being posed by the members of the board. That's what I'm doing. So if you don't want to ask me a question, I won't answer it.
I'd like to give up some time.
I just had a question in regards to the pictures. I know that you had mentioned Wayne's landscaping and whatnot. 2 parts to the vehicles. Are they parked at nighttime in plain view, or, because I can see that they're going to be on the property moving in plain sight during the day, so I didn't know what your complaint was in terms of that. But in terms of having other people use the land, I come from a trucking company, my family owned it, and sometimes you have to use another landscaper maybe to help you out because your truck broke down or whatnot. So just by the pictures, I don't.
Your business is operating off the site, Orlando is. They're operating.
Excuse me, ma'am. You need to use a mic and introduce yourself. You're on television, and that's the law of the selectmen.
Karen Chimkus, to answer your question, Orlando Landscaping is operating off the site, and in fact, Rocky's Landscaping it does not operate off the site as frequently as Orlando. Orlando is running a full-time business off the site.
Okay, that was my question, basically, was about the vehicles. I mean, I
That
agree,
isn't
I
an
agree with Mr.
expansion.
Eagle
I
in
don't-
terms of the,
If that isn't an expansion, I don't know what is.
I agree with Mr. Eagle in terms of the roofing and the big trucks. I mean, I think that's a different issue.
But the expansion involving Orlando is clear. I mean, it's just a point of fact. It's a different business operating full-time off the site.
We have several landscapers in town that have different companies working for them too in residential property. It's not the only one.
Orlando wasn't there in 1983.
I have a couple of questions for Attorney Pizzi. I'm kind of grappling with how, the principles of how we should be interpreting this 1983 variance. I mean, on the one hand, the principle that you espouse is that we should interpret it narrowly and strictly according to its terms, and I agree with that. But then when you apply that to a few different pieces, I start to struggle. So, for instance, the concept that nothing in the business can be conducted on the point, I'm not seeing any language in the four corners of the variance that talks about prohibiting the permitted landscape business on the point. So your argument, I take it, would be that that's implicit because it wasn't being operated on the point at the time the variance was granted?
Well, somewhat. I mean, there's no objection to, I mean, no one's saying that the point has to remain vacant without any activity happening there 24 hours a day. I mean, obviously, to the extent that it may be activity related to the landscaping business, occasional activity that's going on.
Okay, so I think we're saying the same thing. So you're not saying that that the variance prohibits implicitly or explicitly
any activity on the point
conduct of the landscape business on the point.
No, what we're saying is the specific activity.
I'm just trying to walk it through. Okay, so I think we're in agreement there. Mr. Guzmani, a couple of years back, says that any stockpiling has to be done behind the barn, and that's another thing I'm struggling with. I don't see that anywhere in the variance. Again, not within the explicit four corners of the document. If you guys are arguing that, it would be more implicit from the operations at the time?
My interpretation of the variance is that there isn't any stockpiling allowed whatsoever. I mean, other than
I'm talking
occasional.
specifically about this concept of limiting stockpiling behind the barn. There's nothing in the variance on that point.
I would agree with you. I don't know if that was obviously his interpretation of the variance, and for all I know, may have been his way of trying to sort of appease the landowner.
But I think we can agree. There's nothing in here about limiting any activity to behind the barn or in front
other
of the
than
barn
the parking of the vehicles, which I think are clearly stated were being housed in the barn.
So, I mean, because the way I read this is, findings of fact, I mean, as a general proposition, aren't conditions, is a general proposition, right? In any zoning board decision, they're going to have a bunch of findings, or any court decision, there's a bunch of findings of fact, and then there's what you would call rulings of law made by
These days, yes.
Right. So really, it's the rulings of law which is the meat of the decision. So it's hard to say the finding of facts constitute conditions to the grant of the variance. In contrast, the grant of the variance does include a couple of specific restrictions, right? Grant of the variance, not erect signs or any exterior directionals. That seems to be a clear express limitation on the grant of the variance.
Yes.
Yeah. And there's also an express limitation that condition that there must be sufficient off-street parking for employees. I think that's all part of the ultimate decision of the then board.
Yes, I would agree. I have it.
So that's why, I'm trying to draw this distinction between what's in the findings of fact and what's in the actual granting language of the board. And I'm struggling with the concept that what the board found in passing in the findings of fact are being framed as conditions on the grant of the use of the landscaping business.
Well, and this is where I go back to, and I can understand, I appreciate your question, and I refer back to, because I did research this a bit, and I refer back to the Mendoza case that I stated earlier, which was similar. I mean, I think you're correct that today, most variance decisions or any decisions, you'll have your findings and you'll have your conditions listed separately as conditions, and that is most frequently what happens today. Unfortunately, that's not what always happened years ago when variance decisions were being granted, and what we're left with when you're interpreting the scope of a variance, you really have to interpret it based on the language, and that's all you have to go on. In the Mendoza case, there was almost exactly analogous situation where the board made certain findings, and the court said, well, even though it's not an explicit condition, we interpret that as a condition because that's what the board was finding and basing it. It essentially is the grounds for which the board was making its decision. And I think that's what we have here. The decision doesn't anywhere state conditions in those words. But I think these findings were what the board made its decision on. It is at the core of the board's decision. And that's all we have to go on.
If the ZBA found that the house was blue, should we interpret that to mean that, this variance is granted on the condition that the house stay blue for 30 years?
I don't think so. And I think you have to read these. You have
It's a
to
little
read.
murky as to what findings constitute conditions and what
Well,
findings don't.
I think
constitute
the answer is what were the findings a basis for?
But it's a hard
the
thing
board's-
to
it is
parse
a
out.
hard, it is a hard
what-
thing. But again, the rule of thumb is when there's ambiguity in these variance decisions, and I would agree with you, there is some ambiguity, that it's to be construed against the property owner, not in favor of expansion. And so I think where you have a business that has clearly expanded over time, the rule of thumb and what the board should follow, I think, is that allow only what existed at that time.
See, I'm not sure that I agree with you that the Mendoza decision prohibits expansion of a permitted use in a variance. The Mendoza was really a distinction in type of use rather than expansion of the scope of the use. Right, the permitted use was restaurant, bar, lounge, and the issue became not expand. I don't think the Mendoza court would have found that if the bar was 5,000 square feet and they expanded it to 10,000 square feet, that would be a prohibited expansion of that permitted use. What the issue came up in Mendoza is that they were employing a different use than what was allowed. They started employing adult education was a different use and what wasn't permitted under the original variance.
Right. And what the applicant was arguing at that time was that entertainment was part of the variance that was granted, and what they were arguing was that adult entertainment comes within the scope of the variance that had been granted, and the court concluded that it did not, based on the fact that adult entertainment never occurred at the property at that time. And that is where you have the language of the court saying the future uses have to be based on what the past uses were.
It was difference in use between. That's what I mean. It was a difference in use as opposed to the difference in scope of use. I guess is what I'm drawing.
I don't see it that way because the court.
Yeah.
The court was deciding whether or not. I'm sorry. The issue was whether or not adult entertainment came within the meaning of what was allowed, of the bar, restaurant, lounge, entertainment use that was allowed. Much the same way as that we're discussing this evening, whether or not.
I guess it goes to scoping versus the type of use. And like here, it seems like the construction materials from off-site doesn't fall within the rubric of landscaping business. But in my mind, stockpiling loam and gravel and dirt in connection with the landscaping business is part of the scope of any landscaping business, whether or not they were stockpiling it in 1983 or not. Right.
I think there's, yeah.
In your
you're co-
bar analogy, if they expanded from 5,000 to 10,000 square feet, that wouldn't be a change in use, it'd just be expansion of the permitted use. Or if the bar, did a gut renovation as opposed to
Although,
doing a different use.
I mean, I think the
Excuse
outcome
me.
would be the
Excuse me.
same. I mean, if a board grants a variance based on a particular size of use, and I think there was a case, I'll look in a minute, that
Is there a case that says that if they just expand the size of it, then
There was
that's
a case,
a not permitted
Excuse me.
variance?
I'm going to interrupt both of you on this because we're getting into a decision here of other legal cases, which you're a lawyer and you know them, which we don't. So I think
don't know any more
to
about
go
than what she's
forward,
presented.
the one issue as far as the stockpiling of material, the landscaper, a lot of landscapers do jobs and they bring material and stockpile it on their site for a few days and then take it, bring it someplace else or whatever. That's common with landscapers all over the place. The issue, I think, is where we're at because of things that are said, is that we have town council be involved in where we're at this. Presently, town council is getting a decision of a thing of legal representation through the Ethics Commission, because at one point he represented these people in front of the town of Southborough. So he's pretty well got this information done. It's not finalized, that's why he's not here tonight. So, and he can't review any of this until it is finalized. So I'm going to request the board to continue this public hearing until the meeting we have in, not the end of this month, but the next month, because it's got to be reviewed, and if for some reason town council can't do it, then we're going to have to hire special counsel and then have to go through the board of selectmen to get permission to do all that. Our next meeting after, no, the next one. Well, it'll be the 28th, right? What did we say? The February meeting will be the 25th, which we talked about before. So, I mean, I don't know if the board agrees or disagrees with me on that, but I think it's what we have to do properly right now because of some of the legal questions that were brought up and all these other different legal cases, which I don't understand them. I mean, Tom's read them a little bit, so he does, but I know the rest of you haven't. So would the board agree that we extend this until the 25th, and that'll give town council the time to get his legal interpretation that he can do it, and then if he can't, we're gonna go to the Board of Selectmen and have to get permission from them for another special counsel to be involved, and that can't just happen in a few weeks. So,
I would agree with that, yes.
okay, Mr. Eagle?
I'm fine with that.
Lisa? No? Okay.
Can I-
In that, excuse me, ma'am, go ahead.
Can I, before you do continue the hearing, can I respectfully request that I think there's two other abutters who came this evening and have patiently waited, may they have an opportunity?
When I finish with the board, yes, I'll let him. He's already made a comment, and I will. I just want to, when we're done
Absolutely.
here,
Understood.
we haven't opened it to the public yet, which we will in a few minutes.
Okay.
So the board is agreeable on that decision, all right. So, ma'am, do you have any more discussion right now?
No, I mean, I was going to just respond very briefly to the
I won't make you
Mr.
pronounce my name.
Bizik's question
We'll let
about
you do it to town council next time.
size. I mean,
Or
if
a
you want to
council.
jot down, though, I can give you a case site for a case that did talk specifically about size and expansion of a structure that was limited in size, that was then expanded and determined to be beyond the scope of the variance. It's Lucier versus Zoning Board of Appeals of Peabody, and the case site is 447 Mass 531, and it's a 2006 case. And it was a garage expansion, and it was an issue of whether the size, whether the condition was, whether it was specifically conditioned on the size, where it wasn't specifically stated as a condition, but was parenthetically
Okay,
referenced.
that sounds like it would be relevant. There was no express limitation to the then use in that.
It was
variance.
parenthetically referenced as what the size was, but it wasn't under a quote-unquote condition.
Good, thanks.
Okay, I will open it up to the public. Yes.
My name is Bill Pollock. I live on Flag Road. I'm not in a butter, but I travel every single day past 1 Lynbrook. But the reason I would like to just speak for 1 minute, I've lived in town since 1957, and I worked for Clayton Rock in the 70s, putting myself through college. And when Mr. Beals, Whitney's father, sold Clayton the property for a very nominal fee, we moved from that time where Rocky was on Chestnut Hill Road to there, and we'd go, and the present Mrs. Rock was his wife at the time. I'd go there every single week to pick up my paycheck to that house. And he and my father had a very, very good friendship, and he allowed my father to be part of his decisions as Rocky was growing a business from having been caretaker of the property of Mr. and Mrs. Beals to going out on his own. And I happened to be at the right age to get a summer job and work for him. At that time, we would park our vehicles, if we had a vehicle, 2 or 3 of us would carpool. We'd go into the driveway and park in the driveway at the time. And Rocky would, for short periods of time from May to September, would have piles of mulch like any landscaper would have, like Wayne Anderson, who's my present landscaper, has on his property every once in a while, and across from it on Deerfoot Road. And to make a long story short, Rocky's intentions all through that period were very honorable and wanted to keep his own house and property neat and clean, at raising his wife's family at the time, or helping to raise the family. The boys then that you speak of now were much younger, obviously. I'm talking 40 years ago. And and he also prided himself on having his own lawn and his own property, the Point, look as nice as possible. That's what his intentions were at the time, and we mowed that and helped keep that the way it was. His business, right into the early 80s, because he remained a family friend, actually till his death in 2011. My father died in 2005, so after that we weren't so close. But his intentions were to please his clients in Southborough. Was part of the largest job Rocky ever did for 10 years in Southborough, across the street from my present house. Anyway, to make a long story short, we've been here a long time. His intentions to stockpile loam and even sod that he bought that was pre-cut from Rhode Island and Maryland when it was delivered was always behind his house, because that's where he and his wife, in running their business, decided to put it, was near the barn. And the 2 or 3 trucks and or front-end loader or backhoe that he might have at the time were all neatly, and it was our mandate to neatly make sure everything was parked there correctly. I only worked for him for 4 years, like in that capacity, but I remained very close to he as his business expanded. He'd ask me a lot as I went through my business life about business decisions. And to get to my final point, at one point somewhere, someone upset Clayton Rock because he felt that on the Point it was big enough for him to build another home and get an income from that. That's not hearsay. There's people in this room that know exactly what I'm talking about. And he would constantly tell me that, that I go, Rocky, it's looking a little rough out front out there on the Point. He goes, oh, well, screw the town. Da-da-da. Excuse my language. I know I'm on TV. My parents would kill me right now. But anyway, thanks. I'm sorry, Lee. Anyway, to make a long story short, a lot of us knew the players, and especially Mr. Bartolini with his business in town, et cetera. We knew the Rocks, and we knew what Rocky and his landscaping business, its intentions were. I gave him leads for other business. We all did. We loved the man. But what he intended to have a business was to be able to run a landscaping business, much like Wayne's business. I've heard Mr. Anderson's name brought up here. Much like my father helped Wayne get 10 or 12 clients, he did the same thing, and so did I with Rocky. I will go on record as saying he never wanted stones, gravel. Rocky wasn't in the driveway building business. He wasn't in any part of that business, nor did he have any intention to it, because, as he always said, the money was in the landscaping. For all those landscaping uses and products, he kept them behind. No matter how big his business would have gotten, it would have always been back there until, as Chairman Bartolini might very well remember himself, this issue of the town or whomever disfavoring the idea of him building another house, whether it was for his adopted sons or whatever, in front of his present house. And at that point, the man changed a little bit, and he started putting all sorts of stuff out there and tearing down the beautiful trees that were along Lynbrook Road on that side and everything. And that's where I'm going to stop talking, because I don't like to speak when I don't know something. But I do know what I just said as being fact. I worked for the man. He was a friend of our family for 45 years. He spoke to us every single week. And I know that he would consider what we drive by in the dust and everything else, he would consider that even now an eyesore himself. And once again, he's up with the Lord. We can't hear his voice, but I did work with him, and I wanted to offer my opinion. So, thank you.
Thank you. And the other thing is, just for the board, because I do know what was done, that Mr. Rock did come in for a use variance for the additional house, and there was a thing because of frontage setback and stuff that it didn't fit, and he was denied the use variance by this board, and that was 14 years ago that was done.
Right.
And, you know.
Unfortunately, the land is a piece of pizza and should be, just look nice.
It's just,
you know?
yeah, it was close. It's 1.78 acres, I think. And it was short of the acreage for the use variance, and then it was short because of frontage, or he couldn't put the, because of the road coming to a V, side and front setback. So he did go in front of the board to get a variance, which it was denied for. So, what you call saying.
Thank you.
You're welcome. Anyone else? Mr. Beals?
Thank you. Whitney Beals. I live at 10 Chestnut Hill Road. I'm not actually in a butter, but I grew up on the abutting property. My mom is still living at 2 Chestnut Hill Road. I've written a letter that I won't take the time to read into the record, but I'll give to Attorney Pizzi so that she can get it into the record.
You can do that, sir.
Thank you. Or I can hand it in now. Thank you. Just want to make the observation that I believe Mr. Pollack, who spoke before me, was accurate in the way Rocky seemed to have changed his use of the property following the denial of his request for a zoning variance to allow a second residence on that property. I'll also observe that my parents sold the property to Rocky and his first wife, Georgiana, in 1971 for $1. And the reason they were able to do that was that Route 30 used to be Lynbrook Road and is in its present location because the state relocated it due to the construction of Route 495. And in that relocation, they took property from my parents. It divided what was a triangular piece of land between the Aqueduct Channel and Northborough Road and Lynbrook Road, now what then Route 30, which created the 1.91 acre lot, I think it is, Mr. Bartolini.
Is that what it was?
Which was a hayfield when I was a youngster, and part of a meadow that surrounded the central wetland, and all that changed substantially with the relocation of Route 30. But I did talk to my mother, and she said that in recent years she's been quite upset at what's happened on the so-called point portion of the Rock property, and that she and my dad, who died in 2006, I think, yes, or 2008, never would have supported the 1983 zoning variance request had they known that the kind of activities that have happened in recent years might go on that property. Thank you.
All right. Any other resident? Okay, one comment which I'm going to make is the fact of that I understand what both people have just said and everything, and there are some issues that were brought up by Mrs. Shimkus and the attorney that could be entertained, but not by this board. They could be brought in front of other boards, building inspector, or different things, versus the issue that we presently have in front of us of the existing use variance that was granted in 80, whatever, it was 86 or whatever, versus what's changed over the years since then. So our board, which I think we need to talk to council about and discuss is the fact that the way we should go about this, because there are certain issues that could not be right presently, but it's something that our board, I personally realize that our board does not have the legal authority to be involved with them. But you people, as abutters, have the right to go to certain boards in town to take care of those issues. So I think if the board agrees that we have town council be involved, and hopefully he can, if not, we'll have to get special counsel involved in this, that we'll continue this until then, until we know and go over the issues with council and come back and further discuss this matter where we're at. So,
I
you
just have
go
a
ahead.
question
You
on-
can go
I
ahead.
just have a question, a point of
Yes.
clarification. So, it was my understanding that the board is going to seek advice of either special town council or not from town council who indicated he had a conflict, correct?
No,
Or-
we are going to do it from town council. The only issue is presently, he is in the process of, I had asked the Board of Selectmen 2 weeks ago to give me permission, which I have to use town council for anything. And in doing that, they did give me, the town administrator, Mr. Purple, gave me permission to do that. And then town council then, realizing of what he had done, that he needed to get a legal authority notice that he could go forward and do this. So what he did was he went to the Ethics Commission, and they made the statement of what he could do, and then at the further discussion, he was told that he had to go to another board, which I don't know what the other state board was. But in talking to Mr. Cipriano today, he has not got a final decision whether he can legally do it or not. So he's presently involved in getting that done, and hopefully in another few days or a week or so, he will get a legal decision from the state that he can represent the town, or he can't. If he can't, then he'll go to the Board of Selectmen and make a recommendation to them that we need to hire a special counsel to do this process.
Okay, I understand that town council, from what it sounds like, is taking the steps to deal with the state to make that determination. I would just, for the record, like to state my objection of having town council in this matter offer an opinion where he has specifically represented the property owner in the past. Obviously, the board and town council will do what they see fit, but I would like to just object for the record.
Well, we have,
based on
I mean,
a perceived conflict.
You can, we can't make that decision. It's going to be done by the state. And they're the ones that are going to say whether he can do it or not.
Will that be made available as part of the public record?
I think
Oh,
just if I could
definitely.
clarify. I don't think he's talking about the State Ethics Commission. So I think what happens is you seek an informal. I don't know if you've ever done in your career. You seek you present the hypothetical to the State Ethics Commission. They give you their opinion as to whether they think there's a conflict or not. I think that's all he's going through. I'm not sure there's going to be.
It's not, but it's, from my understanding, it's not a
Excuse me.
binding determination.
He's done that already, and they've sent him to another board for some more legal information they have to get to make a final decision. That's why it hasn't been done yet.
Oh, okay. I wasn't understanding. I didn't
Yeah,
understand that he was
just
going to get a
another step.
formal.
He had to go another step forward. And the reason Mr. Cipriano is doing that, because he wants to make positive that he is doing the right thing and not doing the wrong thing. And that's what the process is. And when the process gets done, it will be legal, because then he will go in front of the Board of Selectmen, which he'll have to tell them the whole process of where he is and what he's done, so they're aware of it. And if it's approved, he'll tell them that, and if it's not approved, then he'll request that they hire special counsel to represent our board at that. But it definitely will become public information, and I will see to it, as long as, if you give our secretary, Karen, your email address or whatever, as soon as we get a determination, I will get that email to you, so you know where we're at,
Okay, I appreciate that.
definitely. And I will do that as soon as we get it.
Yeah, I'm not familiar with what steps he is taking, and I understand that he's doing that. Again, I mean, I guess I just would state for the record that on behalf of the petitioners, because he has represented this property owner in the past, that it would not be appropriate for him to offer an opinion in this case. But
No, from what I
That-
understand,
that's-
I don't think that's technically gonna be an issue. It's 14 years ago. Mr. Rock himself has passed away, and it's just so, but like I said, it's nothing we can say or do. It's something that comes from the state. Yes, Mr. Beals?
Mr. Chairman, if I can offer an observation that may come under the category of advice that wasn't solicited, and I apologize for that. But one of the things I've been thinking about while listening to all this good discussion is that the word context hasn't been used. And I'm thinking of the context in which, under which the prior board issued its decision in 1983. We heard Mr. Pollock speak to the fact that any stockpiling of materials actually took place in and around the large garage which was housing the vehicles. And it seems to me that that is, while it may not be an explicit condition as spelled out in the decision, that in fact it was in that context that the board thought the business would carry forward. And I would ask you to consider your decision on whether or not to vacate or overturn the building commissioner's most recent letter or opinion in that same context,
Right.
1983.
What'll happen, Mr. Beals, is this meeting is televised, so Mr. Cipriano will be able to review it all.
Right.
And everything, and that issue, and all the issues that were brought up by the attorney representing the neighbors, to represent and support of the neighbors also, will go into all these different issues that have come up tonight, and Mr. Cipriano will very strongly review it all, and then it'll come back, and we'll do it, he'll be at a public hearing, or another attorney if he for some reason can't do it. But it will go in all these issues like that, and there's a few other issues too, which I will sit down, we'll ask the board for permission, once this is certified, to sit down with Mr. Cipriano and go over with all these different issues, and I do not have a problem to bring any of them up. I will be very happy to do that for all the neighbors to, clarify where it's at and what should be done properly.
Thank you.
Can Mrs. Shimkus make a final comment?
Yes, definitely, as long as she uses the mic.
Karen, 8 Limerick Road. Is it working? Yes. I just want to thank you for your time tonight. I know this was pretty extensive, and the variance itself is not well worded. It was written quite long ago. But I think on the basis of what we've described, it has been very disturbing to us in our household, as well as our neighbors who have sat very patiently through tonight. You have a whole separate business operating off the site, Orlando Landscaping, and if you can't define that as an expansion, I don't know what is. Frankly, it's a little disappointing to me that some of you have gone and visited the site, but didn't knock on our door and didn't visit the abutters, the neighbors, to hear their point of view.
Say that again now?
I'm a little disappointed that some of the board members have gone and visited the site and walked the site of a property owner that didn't bother to show up tonight. And it would seem to me the burden is on them to come and explain what is going on at the site.
Okay.
But no one came and knocked on our door or our neighbors' doors to hear their point of view.
Okay.
I did hear a disturbing reference to beautiful homes. It's not about beautiful homes. It's about disturbing behavior that we have reported, in full fashion here. And I think that all, again, needs to be considered in context. So thank you.
Okay, Mrs. Shimkus, I'll make a comment, which I thank you for the statement, because it's a regulation of this board that we're not allowed to talk to people outside of a public hearing. So we have the right to go on somebody's property and walk it. We are not allowed to talk to the Rocks, anything about it, nor any of the abutters, the people that did the appeal or anything. That is a law by the state that we have to go by. So we can't go and do what you suggested. We have the right to go and walk and look, but we can't talk to anybody unless it's publicly at this meeting. That's why nobody talked to the butters or anybody on this. It's just a standard process that we legally have to do, and I think your attorney would be aware of that. Yes, sir.
Well, you can legally, this is just a point of asking, you can go on to the Rocks property without asking them if it's all right if you go on to their property?
Yes, we can.
Oh, okay, I didn't know
can.
that.
And we had a thing a few years ago that came up, and somebody had complained about it, and we were returned by town council that we do have the right, if we go on the property, we have to knock at their door and let them know
Oh.
we're on their property.
Oh, okay.
But we do not have the right to talk to them about anything. That's a law that we have to go by.
Thank you. Thank you.
Okay. All right, any other comments? Mr. Shimkus, Peter? You have to, just to get the mic from your wife, you got it right.
I'm kind of laughing because Southborough's changed, unfortunately. It used to be a place where, we all get along pretty good and had a, pretty nice time. And it's just a shame that we have a spot where Rocky, who is very good friends with my father, he just turned on us, and he did something right across from our house, which I would never do to a neighbor. Never, ever. I wouldn't even think of doing it. I could, because I own the property right across from his driveway. And I guess two can play that game, but, it's just, I'm just kind of disappointed in, the attitude of Southborough people. And, it's dribs and drabs. You let little stuff like this go away, and the town goes away. And we've been able to keep it through the hard work of people like yourselves. We've been able to keep it up over the years and keep a town pride different from the other towns that let it run amok. And thank you all for that. And I just hope this comes out okay. Maybe we have the Open Space Committee could buy the point. And they can't build on it because they don't have an acre, which you pointed out, Chairman.
Yes.
So maybe that's a possible solution.
Okay, are you all set?
Yeah.
I'm going to make a comment that you said that I think a lot of us, especially people that lived in this town for a long, long time, is one of the reasons the use variance was written the way it was written, because if you go back and read use variances that were done a long time ago, that were done for residents that have lived in town and were friends of your family or my family or somebody else's family, the use variances were written the way they were because of the relationship or the way things were. Nowadays, this board and board prior to us are very strong in the way we do a use variance or a variance or any kind of a decision. We're very, very specific, and the details of these ones that the older ones aren't. And the reason is because of the way the community was it still is very tight and close with people. And that's, so some of the things were, a little bit, doors were left open a little bit. And that's, which if you go back and look at some of these, we've had issues come up in front of us on different things that were done years and years ago. And, the same thing, it came up. And that's I think, your comment as far as you're saying the way the town was and residents were is one of the reasons why it's that way. And I think between our board and town council, that hopefully we'll be able to straighten this all out and it'll come to a decision that'll do something to clean it all up at the end, one way or the other, which we don't know just yet. So if there's no other comments, I need the board, one, to make a motion to give me permission to talk to town council about this after we get a decision from him that he's gonna be able to do it. And we need a motion to continue the public hearing until February 25th. And we'll put it, the first one on the agenda at 7:30, Tom, because you don't like 7 o'clock. Is that all right?
Yeah.
Okay, so can we get the first
Excuse me,
motion?
I'm not gonna be at that meeting.
February
February I will. but I'll be-
25th.
I'll be at that.
That's why, one of the
Yeah, yeah, yeah.
reasons, because I know you're not gonna be at the 28th
Right.
meeting, that's one of the reasons why I wanted to continue it, Mr. Eagle, to
That's
that
fine.
date. Also, plus, I think we need the time, because if council has to review all this stuff, and if somebody else does, it's a whole different, so I think we need to have that proper time to get this done, to make, so it, hopefully we get another meeting and we can finalize it all. Okay, so I need a couple of motions.
So I'll make a motion to extend the meeting till February 25th.
And let's do it
Hearing till February
7:30.
At 7:30.
Do we have a second?
Second.
All in favor? Aye. Okay, and the other motion is to give me the right to talk to town council as we going forward with this. So I need a motion for that.
Make a motion to allow you to speak with town council.
Okay, second? All in favor? Aye. Okay, and now we need a motion to, well, we continue the public hearings, we're all set. So, we thank you very much.
Thank you for your time this evening. Appreciate it.
What's that now?
Thank you for your time this evening.
No, you
I
are,
know it's a
and
long
like
evening,
I
so thank
said,
you.
make sure that you give Karen your email or whatever, so as this goes on with council and stuff, we'll let you know, and you can let your representatives know where we're at and what's happening.
Okay.
Thank you very much.
Thank
Good
you.
night now.
Is there a meeting on the 28th?
Yes.
Of this month?
Yes.
It is.
A couple of things, before we close the public hearing. We get a vote to approve minutes for December 3rd. Paul, we got a thing to approve minutes for December 3rd.
Oh,
Those are sent, yeah, those were
Yeah.
sent out, right?
yeah.
Aaron, go ahead.
Because I wasn't here, so.
December 3rd.
What do you want, a motion, or you want to vote? What do you want?
We want a motion to approve the minutes.
Oh, I make a motion to approve the minutes from December 3rd.
Okay.
Second that?
All in favor? Any other discussion? Oh, yeah, we do have another thing. We have a thing for 134 Route 9 Turnpike Road for a sign variance. So it's going to go on the February agenda.
Do you want me to give you the application now?
No, we can just, with the package, and would take, and the thing is, I want to make the time limit. Now, we've set, that's going to be,
Which property is that?
Yeah, what is,
134 Route 9. That is Billy DePietri's variance way in the back up on the hill. You know, the building way in the back on Route 9 by White's Corner, and the way up in the back, which is a use variance for that building. It's a residential district, and they want to put another sign on the building, which they technically can't see it.
Yeah, right, it's in the woods.
It's going to come in front of us.
Okay, I got
So that there is going to be, Karen, on the 25th, right? So that there, we should make it for 8 o'clock. So we get a motion to put that in for 8 o'clock on the 25th of February.
I make a motion to put 134 Turnpike Road on February 25th at 8 o'clock.
Okay, second? All in favor? All right, okay. Karen, is there anything else that we have to do? That's it, right?
What are we gonna do on the 28th of January? That's going to be the Park Central? No, never mind.
No, we have
Yeah,
nothing.
what is on the
We have
28th?
nothing on the 28th, except for this, an apartment on the 28th. That's the
The
only,
accessory apartment, right?
right, accessory apartment.
Oh, on our
Oh,
difference, that's
this,
not Park
yeah.
Central, that's.
No, nothing to do with Park Central. Where is it?
4 Old Harry.
Oh, Harry Road, which I think she sent that out to you guys.
Yeah, I have it.
So
yeah.
that's gonna be, that's.
Nice
oh, yeah.
pictures, looks beautiful.
And that's on the meeting at our last meeting, we had gave her 2 times to do it, and she said it at the 7:30 agenda that night, which,
That's the only thing else that's gonna be short.
okay, that's the end of it for that night. The other thing is that I had made a statement to the board a few weeks ago about doing things as far as changing the accessory apartment bylaw and the a bylaw on duplexes, which we need to vote on it to do it. Then we have to write it out, and then we have to do a public hearing with the planning board and everything. And due to the fact the selectmen closed public hearing, closed the agenda for town meeting last night, and it wasn't ready, I'm just gonna wait until we get through what's been going on, and we get a meeting maybe back, and we'll put it on the agenda to discuss it on the 28th for a few minutes, and we'll go forward with it that way. But right now, I wanted to try to get it at this year's town meeting, but we're not gonna be able to. It's just, it's too late, and if we had done it before, but legally, the proper way of doing it, that the board needs to agree to it, then I'll write a draft, and boards all can be comments, we'll write, Tom especially can help, and we'll write the draft and discuss what we wanna do. And all we wanna do is correct them, so they're a little easier for approval. There's major tax issues with these accessory
You don't
apartments.
have to wait, you don't have to wait
2 year.
the 2-year period. Is
On the duplexes, the thing, on the change I want to make on the duplexes, that I'm going to put in that you do not have to wait the 2-year period. And the thing is, you build one looking as a single family, which the criteria on it is you have one door in the front, you go in the door, and there's a right door and a left door to get into the 2 apartments. And the thing about the 2-year wait, my personal opinion is, it really doesn't make sense.
No, it doesn't make sense.
To make somebody wait, because when they're building it, if they build it that way originally, so somebody goes and Paul's neighborhood and builds a house next to him, and then in 2 years, he comes back and makes a duplex out of it. Well, they should do it up front. Let
Do
the
it right the
people know.
first time.
Let people know up front. And the issue with, these accessory apartments, the way they're done, there's an issue where a duplex gets taxed a certain way, and accessory apartments don't. And then there's been many cases with accessory, like this accessory apartment that we had before that was built without a permit, the last one that was in front of us. And then they try to make it into a rental thing. Well, this is things that are going on, so that's why I think we need to clarify the accessory apartment regulation only to what has happened in the last 20 years or 15 years, the way this board has approved them, that we put that into the decision written and make it, so it makes it clearer and easier for us and the building inspector to do so. So I'd like to put that, Karen, on the agenda on the 28th, after we do the other thing, so we can discuss it a little bit and go forward.
That sounds good.
What?
Sounds good.
All right, Tom, everybody agree? And I'm curious, would you people be in favor of doing this?
That's
The change of bylaw?
Yeah.
Yeah,
And what we,
are we gonna do a little more study on it? It sounds good. Is there more, just?
yeah, we'll go over it, and what we'll do
I
is,
just wanna understand
we will discuss it a little bit at the next meeting, and then I think we bring David Robidoux in to the building inspector to discuss it with us and get it set up, and then we have
Mark?
to take, and I've already talked to the town planner about it, and what do you call it, and then the planning board has to hold a public hearing and everything, and then we get going. I'd like to make a joint meeting between us and the planning board to discuss the whole thing, so. But we'll do that starting after, and we're just not gonna get it done for this town meeting, but we'll have time to do it. Okay, any further comments, Karen? Karen, both of yous? Okay, I have a motion that we adjourn.
Oh, I'll make a motion to adjourn, yes.
Do we have a second? All in favor?
I'm opposed.
Oh, well, that's why you came here late.
Thank you
You
very
can stay
much.
for an extra hour.
Good night.
That better be in the minutes if you oppose, by the way.
That's the first. Opposing to.